Morning, everybody, and welcome to the District of Columbia Court of Appeals. I'm glad everybody made it here through the snowy streets this morning. We have three cases on this morning's regular calendar. The first is 24 BG 581 in re Stephen VILLARREAL, bar registration number 482284.
Good morning, and may it please the court. Jack Metzler for the Office of Disciplinary Counsel. I'd like to reserve 3 minutes of my time for rebuttal. We're here today because the court did the disciplinary system a favor in the Dobby case when it provided guidance on the appropriate use of stays in disciplinary sanctions. What the court said is that stays are typically reserved for cases in which the circumstances tend to explain the misconduct or blunt the respondent's culpability for it. And that makes a lot of sense. The court explained that the length of the sentence or the length of the suspension reflects the seriousness of the misconduct, and the stay reflects the fact that the respondent shouldn't or be held entirely responsible for it.
I mean, this is one way of looking at it, the way that Dobby did, but what are you saying? Dobby is controlling on us, and in all future situations, it must be applied only to the same on the same grounds?
No, Your Honor. I think Dobby is it's descriptive of the and accurately descriptive of the prior cases. Now, it's not that they are all 100% on all fours, but I think it is an evolution of the law, and that when the court provides that kind of guidance, it is especially valuable, and we, the other actors in the disciplinary system, should listen. But the Dobby standard actually makes a lot of sense. What the court said is,
you call it the Dobby standard, but you also refer to it, I think, pretty accurately as trying to be descriptive. I mean, the exact language was not saying, here is some new guidance, we're clarifying an uncertain area of the law, we're changing the direction. It was typically a certain thing is true. It was just descriptive. And so why does Dobby change anything? Why would we, Dobby said a certain thing was typically true, and we can look at our cases and figure out whether it was typically true. But I just am not sure why it is a standard as opposed to an observation about our prior law.
Sure. Well, I'm advocating here, so I like to call it a standard, and I think that the cases in which the court provides this kind of guidance are especially valuable in our.
I guess what Judge McLeese is asking, and I'll reiterate the question, is why should we call it a standard versus not? And calling it a standard has implications, right? Then it's, we have to apply it. It's some sort of bar or test or, analysis that we have to walk through, versus kind of, this is generally, what we see when we look at these cases, but doesn't preclude other ways of thinking about stays.
Sure. Well,
and again, I'd love you to point me to something in Ray Dobby that suggests we are announcing a standard for how stays should be granted.
Well, like I say, I think the case is descriptive, and I think accurately so. And I do think it makes a lot of sense. When the court said that the length of the suspension reflects the seriousness of the conduct, that is sort of on its face true. When the court enters a sanction, it is saying, for particular conduct, it's saying this misconduct justifies this length of suspension. Why would you say that otherwise? And what a stay does then is it gives, as a practical matter, and it gives the respondent a break, and there should be a reasoned basis for doing so.
Right, but why should that reasoned basis be primarily one that relates to especially the kind of narrow definition of culpability that you have? I mean, there might be other reasons. There could be, it could be that the seriousness of the conduct suggests a period of suspension, but there are kind of varying considerations about the nature of the good work that the attorney is doing. That means that under appropriate conditions, it'd be on balance better not to actually implement a stay that would interfere with practice. So there could be lots of reasons. So why does it make sense as an original matter, leaving aside kind of whether Dobby was trying to change anything, but why does it make sense as an original matter to have a primary, even much less kind of exclusive emphasis on what seems like one consideration that would be relevant to whether you would want to stay a period of suspension?
Sure. Well, I don't think I would hang our case on the word primarily. That's the way they described it the court described it in Dobie. And I think it's generally.
I think the word in Dobie was typically.
Typically.
Right.
And I think that is, I think that's consistent with the cases, but again, I wouldn't hang our case on that. What's more important is that there be a reasoned basis. And we mentioned in our reply brief, there are several other types of reasoned basis that could justify a stay. One being, yes, in Dobie it was they aren't fully responsible. The conduct would justify this length of suspension.
Well, let me give you do you think that if there was a circumstance where the board determined that a particular misconduct had occurred and that its severity was such that a suspension of a year was warranted, and then the board was trying to figure out, the hearing committee in the first instance, and then later the board was trying to figure out whether a stay in whole or in part would be warranted, and one of the determinations was, let's say, that the person has been extremely remorseful and the board or the hearing committee are very confident that the conduct at issue wouldn't be repeated in light of that remorsefulness, and that therefore a need for an actual interruption in practice is not as strong as it might be otherwise. So kind of extraordinary remorse and confidence about lack of a better term, recidivism. Would those be the kind of things that could justify
Sounds like you're describing one of our
staying of a suspension?
Yes, it sounds like you're describing one of the language from one of your prior cases, and I won't try and remember which one it was, but certainly the court has used that sort of rationale before. Now, what I would urge is that it's helpful to connect the sorts of reasons that would justify a stay to the stay itself. And not.
And then would you view the hypothetical scenario I just described as one in which the requisite connection has been drawn, or do you think there'd be something lacking if that was the line of thinking?
Well, in the specific circumstance, if I understand the hypothetical correctly, this is someone where we don't think it will be repeated, and so we're going to give them a little bit of a break. Now, are you suggesting no suspension versus a period of suspension, or are you, or is this like 60
give a break
days with
seems,
30 days?
I don't mean to quibble about terminology, but I'll do it anyway, so I apologize for doing it. Let's put it that way. But I mean, give a break is sort of a euphemism. I think what I was trying to suggest was imagine that a decision maker was thinking the balance of interests in terms of protecting the consumers of legal services and the public, and the interest that the lawyer might be serving if permitted to practice, mean that this is the determination about what the appropriate sanction is. I wouldn't be calling it, they wouldn't be thinking of it necessarily as giving a break in some euphemistic sense. It would just be, that's what they think the balance of interests points to.
So I think in that circumstance, that sort of analysis is one that is, I think, very difficult for the decision makers in the disciplinary system to apply in future cases. I think it's more helpful if you can tie the reasons for a stay to something specific in the case. Just, well, it just seems it should be this way or that.
Why isn't a prediction about likelihood of future misconduct specific to the case in the sense that you are using that phrase?
Well, I mean, I suppose that is specific to the individual, and that those sorts of factors could be developed through I think further cases, and it could well be that if that case came up and that's not one where we would object to a stay. But what's not helpful is to sort of just allow the ordinary sorts of factors that go to the seriousness of the conduct to go into the decision whether to enter a stay. So, and the reason is that it's, again, very difficult for decision makers to follow that in the future. What's the difference between a 60-day suspension that is stayed for 30 days and a 30-day suspension? There should be a reason to do one or the other. And, you know, at least in this case, we've got a 30-day suspension recommended with 30 days stayed. And there's really no particular reason why, at least no articulated reason in the board's decision why to enter that sanction rather than an unstayed sanction. What another case that the court has provided, the kind of guidance I'm talking about, is Chapman, in which they described the landscape. Generally, for a first offense, neglect of a single client matter with no aggravating factors, you would get a non-suspensory sanction. But when there are aggravating factors, as there are here, there's typically a 30-day suspension. Now, if you're going to choose one rather than the other, there should be a reason for it that is specific to the case. And I submit that doesn't happen. That there's not that here. There are aggravating circumstances. Mr. VILLARREAL prejudiced his client. She had to hire a second lawyer to do the work she paid him to do. And he didn't show up for his own disciplinary hearing. He didn't, the board and the hearing committee both recognize that displays an unwillingness to acknowledge his wrongdoing, and it is frankly disrespectful of his responsibilities as an attorney and a participant in the administration of justice.
Can I circle back around to one of the points you made early on? I'm still trying to figure out kind of what guidance we should take from Dobby on the topics that we're discussing. And you said that you view in the terminology when you're referring to Dobby as descriptive, you were saying inaccurately so. And the idea that you're suggesting, which is really if you're figuring out the suspension piece of it, that's where severity comes in, sort of, or severity with respect to the conduct. And if you're going to have a stay, your narrowest view is it has to be a particular kind of culpability blunting circumstance, not just any mitigating circumstance, but even moving beyond that to some kind of a mitigating circumstance. Your view at least is that it shouldn't just be that stay and suspension are floating around as considerations that affect the overall severity of a sanction, and you kind of mix and match them in whatever you think is best. Something more specific about how each of them fit together, a framework for that is necessary. If you look at our prior cases that involve suspensions of stays of suspensions, I keep trying to get this backwards. Do you actually, other than in the language that you refer to in Dobby, do you see that as what's happening? Do we have in our cases, do we say, okay, now we're figuring out and reviewing or making decisions about the length of a suspension, and now we're shifting to a different inquiry that has got a different focus and structure, which is about whether or not that suspension should be stayed or in whole or in part? Do you see that, or is it really Dobby where that principle, if it exists, emerges? Or because you say, again, Dobby's accurately descriptive of what you think is a distinction that we should carry forward, and I'm just wondering what other cases other than Dobby you would point us to as reflecting that idea.
Sure. So I think that Askew is a case that is, broadly consistent. I think you'll find that a lot of cases in which suspensions are entered, you will see that they are attached. I'm sorry, where stays, I'm having the same problem, where stays are entered with a suspension, that they are, broadly or specifically consistent with what they said in Dobie. And there is one case, and
But just to ask if this is a fair takeaway from the way you're framing your response to the question I asked. It's one thing to say, if you look back at our cases, they can be reconciled with what was said in Dobby in their outcome. it would be a different thing to say, no, if you look at the prior cases, they've actually been drawing this distinction explicitly and applying it. And you haven't so much been saying the second thing.
Right.
Is that because you can't, and I don't mean this in a harsh way, but I mean, is that because you aren't aware of cases other than Dobby that tee it up in an explicit way in the way that you view Dobby as having done, or?
There is
there
at least
cases
one
where you-
case
Yeah.
where, and I'm going to fail on giving you the site. I'd be happy to provide it to the court after the argument, in which this is, explicit, not quite in the same way, but where the court says, we do these things for a reason. If we're and these deviations, we attach reasons to them. I'm actually, it's better than that, but I don't want to over-represent what the case is. But I think the nature of the way that these cases come up, it hasn't been, I think it's fair to say in most cases, this has not been explicitly considered in the way that it's discussed in Dobie. Although I think, Dobie provides the kind of guidance that is valuable, and that the court should reaffirm or affirm or create if necessary in this case. What is a very sensible way of looking at this. And it's not that, and I, to sort of go back a little bit, when I say the way that these cases come up, as Dobie acknowledges, many times it is the board that recommends a stay, and many times there is not an exception taken to that. And so the court, without really doing its own analysis, adopts what the board recommends. They often will say, we see no reason to depart from the sanction recommended by the board. That's not necessarily an endorsement of all of the reasoning, but more a statement that that the court isn't going to overturn it, especially when nobody has asked it to. So there are a lot of those cases. There are the cases where the court has rejected a stayed suspension. I think Askew is one of them. Another case would be, I think, Pearson, which is cited in the board's brief. And if I'm remembering correctly, I think in Askew, what happened is there was a stay. The board recommended a lesser stay, and the court rejected that, but entered a stay and allowed her basically time to restructure her practice. It was the sort of specific remedial purpose to the stay that I was talking about before. And I think, if I'm not mistaken, in the Pearson case, the court found, or that's one where the court adopted the board's finding that a stayed suspension was not appropriate because there were aggravating circumstances. So similar to this case.
Is it fair to say this is I think this is what you're saying, but correct me if I'm wrong. This is not an issue that all the lawyers in your office are saying, I wish the court would finally decide this. We really need the guidance on this.
Well, I wish that the court would do this. And we mentioned this in our opening brief. It is actually a problem. The court has said that sanction is not an exact science, but it really isn't fully an art either. It shouldn't be a matter of each hearing committee's personal expression and sort of open to interpretation. The court's cases reflect a mandate towards consistency, and it is very difficult to have a consistency of sanction, and it's hard to get cases to this court to consider them without these kinds of standards. And we mentioned the one case in our opening brief in which this court, I think Judge Easterly, said at oral argument, why shouldn't I have, the very serious concern about, given the misconduct in this case, that would justify a fitness requirement. But the hearing committee, who had the person in front of them, and he seemed like a nice guy, said, well, maybe we would have that worry about fitness, but what we think should happen is we'd like to give him a stay, and then if in 6 months or a year he doesn't do anything else bad, then he can have a shorter he can have a shorter suspension. And I sympathize with a hearing committee chair who's like that, but that's very hard for us to challenge, because when the cases come here, you say, well, isn't this within the broad range of cases? And the difference between, if that respondent could have, I mean, it was clear from our side, and I think that he probably was not going to be able to fulfill that. But it's hard to say that kind of creative sanction recommendation is outside the broad range of acceptable sanctions. So I think it really is something that's needed and that it's helpful. And in this case, what we have is essentially a fourth category of non-suspensory sanction. And so inevitably, the next respondent who comes up with a case of neglect of a single client matter with some aggravating circumstances will be in here arguing, well, I have the kind of aggravating circumstances that aren't quite aggravating enough. So I should get I should get not a non-suspensory sanction. I should get a suspension that is completely stayed. And so it's still non-suspension, but I should get Mr. VILLARREAL's sanction rather than what would be consistent with other cases. So I do think it is really helpful, and I think the lawyers in our office would cheer for this kind of standard for exactly those kinds of reasons. I see my time has expired, so I'd just like to say that I mean it when I say that the guidance in Dobie is a gift to the disciplinary system, and I think it is. We, the actors, should listen. Cases like Chapman are extremely helpful when we are preparing these cases, and the guidance like Dobie would be extremely helpful if this court were to apply it, and the court should do so in this case. Thank you.
Thank you.
May it please the court, my name is Marie Park. I'm with the Office of the Executive Attorney, and I'm appearing today on behalf of the board and professional responsibility. Before I start our argument, I just want to quickly respond to the case that Mr. Messler was referring to. He cites it in the reply brief in Ray Butler, where their hearing committee had recommended conditional fitness, which is a sanction this court has endorsed previously. The disciplinary council actually argued to the board in their brief that the board should adopt that hearing committee sanction. It was the board that sua sponte decided to impose a fitness requirement on Mr. Butler. This discipline matter involves a lawyer who bungled a case by filing an insufficient motion a few months after being retained. And he was promptly fired by his client. The representation was brief, the misconduct was limited, but it prejudiced the client who had to hire another attorney. From disciplinary counsel's letter that was filed last week, it's clear they now concede that the conditions of probation that the board recommended have real teeth. But they still haven't explained why this court's heightened deference, the board's sanction recommendation, isn't warranted here. As the court explained in Edwards, quote, "We respect the board's sense of equity in these matters unless the recommendation is patently unreasonable or is materially inconsistent with the sanctions that we have imposed in comparable cases." So I think it's undisputed that, but for Mr. VILLARREAL's non-appearance at the hearing, that at the lower end, this case would be in an informal admonition. And I'd like to add, in addition to the informal admonition letters that the hearing committee cited, Inouye Nwadike, Nwadike, it's a 2006 case, and it discusses an informal admonition, and it cites several immigration cases where the range of sanction was from an informal admission to public censure. And it also explained why the Bernstein case was not applicable. And on the upper end, you have In re Mance, which the parties have cited. And I also would like to add In re Long, case site is 902A2nd, 1168. It's a 2006 case. And there's lack of competence, but it was aggravated by a conflict of interest charge. And that case also cited to Boykin. So again, these are fully stayed 30-day suspensions with CLE requirements. Now here, we have just lack of competence, but the fact that he did not appear, the hearing committee and the board correctly took that into consideration, and they elevated what normally would be an informal admonition to 30-day suspension.
Can I
With
ask you
8
about the
hours.
legal question that your friend on the other side of the podium is pressing about how you understand the stay of suspension to work? Do you think that there doesn't need to be any kind of special rationale tied to stays in particular, some mitigating circumstance or some culpability reducing circumstance to warrant a stay, that a stay is just kind of the part of the disciplinary apparatus's tools, one of the tools that can calibrate severity, and it really is, there's no special inquiry that needs to be focused and tied on stays in particular. Is that how you view it, or do you view it in some different way where there needs to be some kind of a connection between a stay and a rationale for a stay?
Well, we believe it's an important tool of the discipline system because part of the discipline system, the purpose is rehabilitation of the respondent. And probation is an important part of rehabilitation, especially when there's a CLE requirement or a PMAS condition, or, a supervised probation with a monitor, practice monitor. So we believe that it's just using the Hutchinson factors. That's what the court did in Dobby. If you look at the Dobby sanction analysis, they went through the nature of the misconduct, the number of rule violations. They looked at the nature of the dishonesty, and they explained that they disagreed with the board because they found that the two U.S. attorneys did not acted only with reckless dishonesty. And they also considered the prejudice to the two defendants who suffered a criminal sentence that was unwarranted.
Let me try asking the question this way, I guess. It was my question, I think was a little murky, but do you think it is in theory appropriate for the hearing committee to recommend and the board to recommend and the court to adopt a stay of a suspension where the analysis, let's say there are no mitigating circumstances, nobody's arguing there's a mitigating circumstance and there's no culpability reducing circumstance. It's just that the hearing committee, the board and or the court look at the circumstances taken together and figure out that the severity of the conduct and the other circumstances that are not mitigating or culpability reducing, but are just bear on the balance of interest in determining a sanction, end up saying, well, this is just sort of where we think on balance those interests point. You can have a suspension, but if you didn't suspend it, that would be unduly harsh, even though there are no mitigating circumstances and no culpability reducing circumstances. Is that a disposition you think in principle is fine? There doesn't need to be any kind of mitigating circumstance or any kind of culpability reducing circumstance to make a stay appropriate in a given circumstance.
Yeah, we strongly disagree with disciplinary counsel's position that something needs to be fixed here. The board is entitled to this deference in part because the board sits as an en banc court. We have 7 attorney members and 2 public members. The 7 attorney members are a wide range. They have a wide range of practices: solo practitioners, government attorneys, attorneys from law firms, and we have 2 public members who are concerned about the perspective from the client perspective. And that's why it's not just DC Bar Rule 11 or this court's case law about the deference owed to the sanction recommendation. It also has a practical purpose. And so we believe that as to whether there needs to be a bright line rule on stays, disciplinary counsel hasn't shown why this stay has put this case outside the range of cases, sanctions for comparable misconduct.
Well, turning back to this case, I guess the hearing committee found 2 mitigating circumstances, and the board's report and recommendation is a little murkier, but does refer to mitigating factors in the plural.
Mhm.
And as I understand it, those two mitigating circumstances were lack of prior discipline
Mhm.
and then partial cooperation with the investigation at the front end, at least. Is that a fair description of what the
it
two
was-
mitigating circumstances were?
They adopted the hearing committee report, which talks about the limited number of rule violations, the nature of the misconduct. In this case, it was.
So, I mean, the first of these is going to be, I will concede, a somewhat potentially unfair question. So let me, we definitely have cases that treat lack of a prior disciplinary record as a mitigating circumstance. So I kind of take that as a given, but just as an original matter, can you take a stab at explaining to me why that should be so? It seems to me that that's a baseline, and that presence of prior rule violations would be aggravating, but why is it mitigating as opposed to the baseline that the respondent hasn't previously had disciplinary violations established?
I think it goes to what you described before, the fear of recidivism. Part of the purpose of the attorney discipline system is to help is deterrence, and also deterrence not just of other respondents, but the respondent himself. So here.
I mean, I get
Mhm.
why it's a relevant consideration. I'm just not quite sure why the observation you're making right now is an explanation of why you treat it as reducing the sanction you otherwise would think would be appropriate. I mean, it's a somewhat academic question, so maybe it's not worth devoting more time to that. But with respect to the other two, if I have a similar question, except I think there may not be the same doctrinal impediment to it, which is why would, if the number of disciplinary infractions, if it's low, be a mitigating circumstance?
Well, it's also the type of rule violation. For example, if this was negligent misappropriation or reckless misappropriation, it doesn't matter the number of rule violations. But here, it's limited misconduct. It's a simple lack of competence.
Yeah, I all of that seems to me to reduce the gravity of the conduct, but I haven't yet quite gotten my head around why any of it is mitigating as opposed to simply that it could have been worse. There's one violation instead of 7. It's negligent rather than reckless. None of that seems mitigating. All of that just seems in the category of this could have been worse.
Right. Well, if you look at the court's case law on the balancing of these Hutchinson factors, there's 2 cases where the court has suggested that a stay might not be appropriate. And that's when there's deliberate dishonesty to the hearing committee and deliberate dishonesty to disciplinary counsel during its investigation. That would be the Avery case and the Chapman case.
I get, and that's related to, but a little bit distinct from what we've been discussing most immediately, which is whether some of the circumstances relied upon by the hearing committee and a little less clearly by the board are properly viewed as mitigating rather than just relevant to the sanction. Let me just, on the third of them, if I recall correctly, the hearing committee treated as mitigating that Mr. VILLARREAL had participated, at least initially, in the process, but then didn't obviously appear at the hearing. And I'm, again, same set of questions, really, which is, why would that appropriately be viewed as mitigating rather than in the category of this could have been worse, but wasn't?
Well, the board did consider that as an aggravating factor. So yes, they credited his reason for not appearing. He had consulted with multiple attorneys, decided he couldn't afford an attorney, and he felt uncomfortable appearing pro se. Now, it's
So just when the board says respondent's lack of remorse and the prejudice to his client are aggravating factors, but they're not so severe as to overshadow in full the mitigating factors. Can you tell me just list to me what you think the board there is treating as the mitigating factors? Not factors relevant to sentencing, but things, or sentencing to sanction, but mitigating factors. What do you think those mitigating factors were?
I think it's essentially he has a 20-year, he's been practicing law in the DC bar for over 20 years. This is his first complaint. And you also looked at the nature of the misconduct and the seriousness of the offense. And it was an insufficient motion that was filed. But if, for example, if our office started taking away attorneys' licenses every time an insufficient motion was filed, it would disrupt the court system. It's not fair to the current clients. The purpose of the discipline system.
I'm not sure what the reference to taking away licenses is. I mean,
Well, suspension.
no one's suggesting
Yeah.
disbarment here.
No, right, sorry, suspend their license, interrupt their practice for 30 days. Here, the board considered the fact that this respondent did cooperate, did provide, complied with the subpoena. This is, unfortunately, we see a lot of respondents who don't respond to the inquiry letter. It takes 4 or 5 letters, possibly a board order to compel them to produce documents. Mr. VILLARREAL promptly replied to the client's complaint and disciplinary inquiry letter. And then he provided over 100 pages of documents, including not just the case file, all the emails. He even took screenshots of the text history with his client. He cooperated fully in the board's opinion. But to take his license away for 30-day suspension, the only cases that disciplinary counsel came up with was Bernstein and Cole, which involved much more serious misconduct. I think part of the issue also is just look at the Dobby case. They could repeatedly cite to that quote on page 814, but the sentence that follows immediately is, we believe this result strikes the proper, though nuanced balance. Again, balance, they were balancing the factors. Nuanced balance that this case requires. If you look at the 4th paragraph of the Dobby decision, they quickly summarize why they're not adopting the board's sanction recommendation of a straight 6-month suspension. In the 4th paragraph, they don't talk about blunting responsibility. They talk about the Hutchinson factors. They talk about their unblemished record. They talk about the nature of the dishonesty. The Dobby court found the nature of dishonesty much less than the board, and that was described in full when they go through the Hutchinson factors in their report. Also, if you listen to the oral argument in Dobby, no party mentioned the word stay. There was no question from the panel about a stay. If you look at the briefing before the court in Dobby, there was never the mention of the stay. The 2 respondents sought a dismissal, and disciplinary counsel sought a straight suspension. The issue wasn't even before Dobby. Dobby is a very unusual case, and I think that you have to read Dobby at its words. And it's not a sensible rule. Like, if the disciplinary counsel is looking for a sensible rule, it would be an unfair rule, because they openly state in page 5 of their reply, solo practitioners, quote, by definition, are solely responsible for the disciplinary infractions they commit. If we made this the new standard, it'd be very difficult for the board to apply it in a fair manner, because only people who work at law firms or government agencies could be eligible for probation under that rule. DC Bar Rule 11 broadly permits the use of probation for the discipline system. And, you know, the discipline counsel also complains about this probation being unsupervised, but unsupervised probation is actually a misnomer. Probation is always supervised, but in the board rules, we call it supervised when there's an appointed practice monitor. But it's unsupervised when disciplinary counsel is monitoring the probation. That's under DC Board Rule 18.2B. Now, going back to some of the cases, and I know my time is up for the court's indulgence. If you look at Chapman, if you look at Avery, if you look at Askew, those are all cases where the court that ultimately elevated the sanction, but it wasn't because they thought probation did serve a purpose. It was because that they used the Hutchins factors and decided the length of suspension warranted being longer. So this court has never, except in the Pearson case, and Pearson was a really unusual case. If you recall, that's a case with the attorney who pro se put a dry cleaning business out of business with his frivolous, vexatious litigation, suing the company for over $1 million. And he continued that misconduct before the hearing committees, before the board, for this court. And the court adopted the board's recommendation that this respondent isn't capable of being rehabilitated. And that's the case law that exists on when probation isn't available to respondent. The purpose of the discipline system, it's not punitive. And
Counsel, I'm just a little confused as to why we're talking about probation. I mean, my understanding was that the core of the argument here was that the sanction shouldn't have been stayed
Mhm.
and that Dobby or Dobie imposed some sort of rigid structure that the board had to walk through and that it failed to do so. And
Right.
so I'm losing the thread of your argument. If you want
Right.
to try and bring me back to why this is
Okay.
relevant to the arguments that are being made.
Sure, because the stay incentivizes the probation. For example, there's the hang time, there's the unsuspended stay time that serves as the to ensure that the respondent complies with the conditions of probation. So in other words, here, Mr.
So the
Villarreal,
state, your point is the state could always be lifted. The probation could be. put
yes,
into
this would
effect.
counsel, the board rules provide how they would file a motion to revoke
And
probation.
just getting back to sort of why this properly before us in this case. Do you understand disciplinary counsel to be arguing both? There's a standard set forth in Dobby, the board didn't apply it properly. And whether or not there's a standard set forth in Dobby, this stay was an abuse of discretion under sort of broader abuse of discretion principles. Is that?
Yeah, I think they're making both statements. I think they've pulled back from their opening brief. If you look at the reply brief, they're acknowledging that several cases, the court and the board have recommended probation and stays that don't involve levels of culpability. So I think they are also saying that in this case, that a stay wasn't appropriate. I think their best argument, frankly, is that, you know, the fact he didn't appear at his hearing, that might be reason to impose a stay, not impose a stay. But here it was very clear. They credited his explanation. Disciplinary counsel did not subpoena him to appear. He is located in Texas, but we know from other cases like Enrique Keg, they can work with Texas Bar Council to try to subpoena a witness. So the board considered his absence, elevating what was an informal admonition to a stayed 30-day suspension. And I just want to emphasize, a 30-day stayed suspension is not a light sanction. If a respondent commits another rule violation, when we look at their prior discipline history, that's going to look significant. For example, in Ray Mance, the court noted he had 2 informal admonitions, but they weren't given much weight. A 30-day stayed suspension is a serious sanction, especially for a first-time offense by a respondent who's been practicing 20 years, and the misconduct was not egregious. It was a very limited representation. If there are no further questions, I would just like to add to that this court, in making its decision, could simply write a decision that disciplinary counsel hasn't shown why this sanction, stay or without a stay, that simply the application of a stay somehow makes this case outside the broad discretion that this court owes to the board. Thank you.
Ms. Park. Mr. Metzler will give you 3 minutes for rebuttal.
Thank you, Your Honor. I'd like to just sort of respond to some of the points in the argument, in the board's argument. Most prominently, I would say that the colloquy with Judge McLeese shows the difficulty that we're talking about here. What the board found as mitigating factors are really just the lack of aggravating factors. And so to count those as mitigating is sort of double counting, right? You say, well, it's their first offense. Well, that just means, as you say, the baseline is you don't commit disciplinary violations. You don't get credit. You don't build up credit over time. And now it's okay. You get 1 or 2 violations because it's been a long time without a violation.
It's a little tricky to criticize the board on the lack of prior record and treating it as a mitigating circumstance, though, because we do have a lot of cases that ourselves characterize it that way, and also accept the board's characterization of that. So whatever one might think of that as an original matter, it's a little tricky to criticize at least that mitigating factor.
Yeah, I don't disagree that language is in a lot of cases, but it's also true that in the circumstances, the type of misconduct here, that's sort of baked into the non-suspensory sanction that's described in the Chapman case. It says, well, for a first-time neglect of a single case, nothing else, you get a non-suspension. If there are aggravating factors, which there are, then you get more. And here they're saying, well, but there's also a mitigating factor, which is, you know, the lack of prior discipline and the lack of additional violations and so forth. And as I think the colloquy shows, all of those are just, you know, sort of the lack of more aggravating. They're not really mitigating in the way that they explain or make the conduct less serious. Just quickly with regard to the Butler case, that case came out, the hearing committee case decision came out soon after Dobie, and at the oral, we didn't take an exception for exactly the reasons that I talked about. It's and exactly the argument that my friend has made. It is hard to challenge a sort of exotic sanction recommendation because, broadly speaking, it is within the range of acceptable sanctions.
I mean, you
Our
call it
argument-
exotic, but I guess I wonder if that just sort of proves the point that, you know, we're looking at each of these attorneys individually. This isn't about punishment. And that speaks to the need for sort of wide-ranging discretion by the board because every individual has their own particular fact pattern and scenario.
And I agree with that. And the board has and appropriately has a lot of discretion in recommending sanction. But what Rule 11 says is, and I think is true in this case, the court will not adopt it if this sanction you know, fosters a tendency towards inconsistency. And the sort of matters discussed in the colloquy with Judge McLeese, and as we've been discussing, this is really hard to apply. It's hard to put your finger on why this person with a first-time neglect of a single client matter with aggravating factors gets a non-suspension suspension, and the next person gets 30 days. And inevitably, the next person will argue that you know, their cooperation was not as, their lack of cooperation was not as bad as it could have been. And with regard to that specific point, this respondent should not get credit for responding to the disciplinary complaint. Had he not done so, that is its own violation. And the court has said the typical sanction for there is 30 days with fitness. If you don't respond to a subpoena from disciplinary counsel, that is a serious matter. You don't get credit for doing what you were supposed to do. That doesn't make your violation any less. With regard to, my friend said that the board credited Mr. Villarreal's reasons for not appearing, and that's, I think, in the first footnote of their, if I'm correct, of the board's report. And he said, well, I couldn't afford a lawyer, and I didn't really want to represent myself. Well, to the extent that is actually the basis of the board's decision, that's error. The hearing committee had no basis to evaluate the credibility of that because Mr. Villarreal didn't appear. Even if he didn't want to represent himself and didn't want to have a lawyer, he could have appeared remotely and at least been present and been a participant rather than just thumbing his nose at the entire disciplinary system and ignoring his own disciplinary proceeding. As for, it's true, we didn't subpoena him, but for the same reason, we shouldn't have to subpoena a lawyer to show up at their own hearing, their own disciplinary hearing. That is the baseline. That is the minimum that you do, and you don't get credit for failing to have even more egregious conduct. Let's see, I'm not sure if I mentioned this. At the Butler case came soon after Dobie, and at the oral argument in that case before the board, we did say, well, you know, Dobie just came down. He really probably shouldn't have had a stayed suspension here. And we didn't take exception, so we didn't argue it too hard. But we took that position at oral argument before the board. And we are grateful to the board for not entering a stayed or not recommending a stayed suspension in that case. And I think that concludes my responses on rebuttal. So I see my time has expired unless there are further questions. I would just say that the Chapman case is one that provides guidance. There are other cases, and I have a list of them. I keep it because they are especially valuable and for exactly this reason. When the sanction comes from a hearing committee, we want sanctions to be consistent with one another. And a sanction like this one is virtually impossible to use and will, in fact, foster the tendency towards inconsistent sanctions. And for those reasons, we think the court should enter a 30-day suspension with no stay and should make clear that the use of stays should be tied to a reason that is specific to the case, a remedial purpose, or circumstances that tend to lessen or blunt the respondent's culpability. Thank you.
Thank you. Thank you both for your briefing and your arguments today. The case will be submitted. Second case on this morning's calendar is number 24 FM 257, ERDIN MATAJ versus XHOISJANA MATAJ. Hopefully I said that okay. XHOISJANA. And I think we are waiting. We have Mr. MATAJ on remote argument.
Good
Can you
morning.
hear us? Good morning.
Yes, I can hear you.
Okay.
May it please the court, my name is ERDIN MATAJ, appellant in the case, appearing pro se. This appeal concerns whether the DC Superior Court could validly issue a custody support order despite a pre-existing Albanian proceeding and ruling. Must DC respect the Albanian High Court's exclusive authority, or can it enforce a second contradictory order? 7 reasons show why the Superior Court's final decree must be vacated or conform to Albania's. Comedy and international law require deferring to Albania's High Court. Jurisdictional precedents under the UCCJA, Albania was first filed. DC needed to coordinate or defer. We have forum shopping. The mother turned to DC only after Albania's jurisdiction was established and her first alimony case in DC was dismissed due to comedy. Double payment. 2 final support orders lead to conflicting obligations. And enforceability, the DC order is meaningless in Albania. A dangerous precedent, disregarding a foreign Supreme Court invites reciprocal disregard of US rulings. And a failure to coordinate. The Superior Court never communicated with Albania's courts as required, ignoring the first filed action. I request the court vacate this. Go ahead.
Mr. MATAJ, excuse me for interrupting, but we've read your brief.
Mm-hmm.
We've looked at the trial court materials. We've looked at all the filings and we've looked at the transcripts. So you have a jurisdictional challenge both as to custody and as to support. In the Superior Court, you told the Superior Court judge that you were not requesting the court to dismiss the child custody portion of the case. That is a quote from your counsel on November 3rd from the transcript at page 6. And
That is
then
correct, Your Honor.
subsequently, at that same proceeding, your lawyer said that you were seeking a custody order in Albania, but were not contesting that this court could have jurisdiction over custody matters. And in the court's denial, sort of preliminary denial of your first motion to dismiss, where it said, we don't have enough information about Albania's interest in this litigation, the court said, look, the custody jurisdiction has been conceded. And in your second motion, so I'm just going to go through the record, in your second motion to dismiss, which you filed after the Albanian Supreme Court said, no, wait, hey, we have jurisdiction over custody and support. you only asked for the support part of this DC case to be dismissed. And again, in the court's order denying that motion, the court said that there was no dispute about DC's jurisdiction vis-a-vis custody, and that's at the order on page 24. So my question for you is, given all the representations that you made in Superior Court about not challenging jurisdiction as to custody, separate from support, why should you be able to argue now that that there's no jurisdiction as to custody?
Well,
I'll just explain. Generally, we don't let parties take conflicting positions in the trial court and then on appeal. And it seems like the record that I just recited shows that you acquiesced to the court's jurisdiction, at least as to custody.
yes, and I understand your concern, and thank you for your question, Your Honor. In terms of custody, the Albanian order that was issued by the Tirana District Court on April of 2024 has the custody similar as DC, which is giving sole custody to the mother.
Right, and I don't really want to talk about the Albanian order from April 2024 because that is really outside of our record, right? You filed your notice of appeal in this case in March. And so what happened in Albania after you filed your notice of appeal is really not properly before us. So just looking at the record of what happened in Superior Court before the court ruled on your jurisdictional challenge, or when the court finally ruled on your jurisdictional challenge vis-a-vis support, why do you think you also preserved a challenge to jurisdiction vis-a-vis custody?
Well, again, I was the first person to file a custody and support and divorce decree in Albania in September.
Be that as it may, let's say we agree with you that at the outset, you filed something in Albania that said, I want a divorce and I want custody and I want a support order, and I think she should have custody and I think a support order should be answered. That's okay, so that's a baseline. But subsequent to that, in Superior Court, you made representations to the court that you were not challenging the court's jurisdiction over custody. And so, and my question is, why do you think we should hear that argument now?
Yeah, I think I understand your question. And again, I just want to reiterate that Albania does not distinguish between custody, support, and divorce. They're filed in one single action. So now we have two conflicting orders, Your Honor. One from DC and one from Albania, and they differ in
We didn't have
court.
to, I mean, if we want to shift to support, at the time the court ruled on jurisdiction with respect to support, and at the time the court issued its support order, there were not two conflicting judgments on support. The Albanian court had decided that it had jurisdiction over support by the time the court rejected your challenge by the time the Superior Court rejected your jurisdictional challenge vis-a-vis support. But the Albanian court had not made any decision about support at that time. And as we just discussed a minute ago, that ruling didn't come until a month after the Superior Court issued its support ruling.
Correct, Your Honor, but the Albanian High Court
So I
actually.
guess I'm curious to know why, right? You cite, you mention comedy, the principle of comedy. And you cite a Supreme Court case that talks about, honoring foreign judgments. but there was no final foreign judgment that perhaps should have been honored at the time that the Superior Court made a decision either about jurisdiction or about support. So I would be interested in understanding a little bit better your argument as to why jurisdiction over child support was improperly exercised.
Well, so if I'm understanding the question correct, and interrupt me if I'm wrong, the Albanian High Court ruled on exclusive jurisdiction before the December 2023 trial in the Superior Court. So
Right,
that,
and that's why you filed a second motion to dismiss. right?
correct?
You had that ruling from Albania saying, wait, we think the trial court in Albania is incorrect. We think we do have jurisdiction over support and
Mhm.
custody. And so you came back to DC Superior Court and said, look, there's a ruling saying Albania has jurisdiction. And the court looked at that and it went through the analysis under the Uniform Support Statute,
Mhm.
the acronym for which I'm not going to try to say because I can never remember it.
Okay,
So I'm just going to call it the Uniform Support Statute. It's
Mhm.
it's DC code. It's 46 35204, I think. Right, and the trial court went through the analysis that in that uniform statute that says, here's what you do if there is another action that's been started elsewhere. And the court went through that analysis and said, I find even under this statute that I can have jurisdiction over this. And I don't see in your brief that you are challenging that statutory analysis. What it seems like you're saying is saying the Superior Court's ability to exercise jurisdiction, because the uniform statute is permissive, right? That set that aside, maybe that statute was satisfied, but it shouldn't have exercised that exercise jurisdiction. And I'm trying to figure out why you think the court shouldn't have, even though it was allowed to under the uniform statute.
Well, under the UCCJEA
Well,
code,
the UCCJEA is about custody, I believe, and
It
the
is.
uniform statute about support is different, and that has its own analysis. And you guys litigated that in Superior Court, right?
Mhm.
And that's why your first motion to dismiss was rejected, because the court said, look, I don't have enough facts to run through this uniform statute on support. Come back to me when you have more information about what was filed when. And so then you did go back to the Superior Court, noting the Albanian Supreme Court's decision that it had custody over support. And the court at that point went through the uniform statute analysis. And as I said, I don't see in your brief that you were challenging how the court went through its statutory analysis. I mean, there's just no discussion in your brief of that. It seems to me what you're saying is, even though the court could have had jurisdiction under the uniform statute, it shouldn't have exercised its authority to hear this case. And I'm trying to understand what the legal basis is for your argument about why the court shouldn't have exercised its discretion. Does that make sense?
I'm a little bit confused, Your Honor. I'm not up to
These are complicated matters, and
there are complicated matters, but I
Yep.
think the Superior Court, I think we have a couple cases, and I want to bring out that the first filed case was not actually the current case that we're discussing, and I wanted the court to take judicial notice of a prior case that was first filed by the appellee. That case was
are you referring to Ms. MATAJ's divorce complaint?
yes, correct. That case
Yeah,
was
I mean,
number 20.
that's referenced already in the pleadings in this case. And
Yeah,
I don't understand it to be disputed that Ms. MATAJ did file for divorce.
right, but that case is also about
That case was
alimony.
dismissed. But
Mhm.
I don't see how that impacts the complaint for child support. And in particular, this issue that I'm trying to get you to focus on now, which is why the court erred in exercising its discretion to hear the custody case once it had figured out that the uniform statute requirements allowing it to exercise its jurisdiction had been satisfied.
Well, all I can say is that under international law, when the mother tried enforcing the DC order in Albania, authorities refused to admit it. So I'm left with
That
with
seems, I
compliance.
mean, I'm just gonna say, that seems a little downstream, right?
Right,
Like,
it is downstream.
what happens if and when she tries to enforce a DC Superior Court order in Albania?
Mhm.
That's really not before us right now. What you are asking us to decide is whether or not the Superior Court should have exercised its jurisdiction to issue a support order. And that's really the only thing that we're gonna decide in this, I mean, among the other issues that you've raised. We're not gonna reach out to address what might happen or not happen in the future.
Okay.
Because, you know, in an appeal, we're just looking at the orders that led up to the final judgment that you then filed a notice of appeal to challenge before us. And we don't look outside of that.
Yeah. Well, I'm going to be honest with you. I wasn't prepared to answer your question. But I would like to stress that still the Superior Court under the UCCJEA and the UAIFSA, they should have communicated at least with the Tirana District Court to decide which was the most proper forum. And in that instance, the DC court should have at least stayed its decision until it communicated with Albanian courts to decide which was the more appropriate forum. And that's really the crux of the case. So now we're faced with double obligations because the custody is very similar and so is visitation. So what I'm faced with is a double obligation. We have a DC case stating one amount and an Albanian amount that's different. I understand you don't have that in front of you, but that still leaves me with a double obligation.
Am I correct that the trial court said that in the event of conflicting obligations, you could file a post-judgment motion to try to address that? And have you done that?
I did, and that was rejected. Yes, that's correct.
Okay, and that could be the subject of a separate appeal.
Okay. So really what I want to discuss is that I'm still faced with a double compliance issue. The benefits no child. It doesn't benefit me. It just leaves me in a double compliance situation. If I comply with a DC order, I'm faced with problems in Albania, up to including incarceration.
Could you be more specific with that? If the DC number is higher, the child support monthly payment number is higher than the number in Albania, and you complied with the DC order, you would be complying with the Albanian order plus more. So what's the nature of the difficulty you think you would be put in Albania if you
So
on child support? At least I'm not quite sure. I see the practical risk that you're.
yeah, so just to clarify, the DC support order puts me in $450 per month obligation plus around $19,000 in arrears, paid in $25 per month, which yields about $475 per month, whereas Albania is approximately $335 per month with no arrears. The issue is that we have two different court directives now, so
No, I understand that, but you were saying that if you complied with the DC order, it could get you in trouble in Albania, and I wanted to make sure
Sure,
I
the
understood how,
applicant,
because it seemed like if you would be fully complying with the Albanian requirements and the DC requirements if you complied with the DC order. So why would the Albanian courts be inclined to take action against you or have you be in any kind of trouble in Albania? I just, that's my practical question.
well, I wouldn't get any credit because the Tirana District Court has refused to recognize the DC order. So the DC order is in fact unenforceable here. So if the appellee wanted
It
to
seems
put
to
me-
be irrelevant whether or not the Tirana court would recognize the DC order. Presumably, the court would recognize your proof of payment.
They, in fact, I have no inclination that they would do so. They were looking at their own law. They're not looking at what DC is doing at all. So I would still face.
Do you have any other arguments that you would like to make to us today? We've talked at length about the jurisdictional issue when you are over time, but if you wanted to touch on any other argument, you're welcome to do so briefly.
Well, I'll quickly go over my arguments. Again-
Remember that we have read the brief, so if there's just something that you want to stress or emphasize, we're familiar with all the arguments that you've made.
Sure. I think that, continuing the things as they are, I just wanted to clear up for like an earlier question. Again, I would be facing contempt in DC if I don't comply with a DC order and vice versa if I don't comply with the Albanian order. And in terms of enforceability, my assets are in Albania. I do not reside in the United States. That could only put me into double compliance and face arrears in DC and face problems upon entry in the United States, which can hamper father-son relationships. So the best interest of the child is not by having two obligations, but by having one single order as required by the UCCJA and the UIFSA. So that is my concluding argument, and I just want the court to take judicial notice of the prior case that I mentioned, and I look forward to answering any further questions you may have.
Thank you. We will give you a couple minutes for rebuttal after your opponent
you.
argues.
Good morning, Your Honors, and may it please the court. My name is Melissa Jacobs of Hogan Levels, appearing on behalf of appellee Ms. XHOISJANA MATAJ. Appellant raises 5 issues in his briefing, none succeed. To start, I want to focus on jurisdiction over child support and clarify why DC has at all times had proper jurisdiction over the support determination.
Before we get to support, can we talk quickly about custody? You heard me ask Mr. MATAJ why he had not, forfeited, conceded territorial jurisdiction. That argument wasn't made in your brief. So do we need to address jurisdiction over custody?
Your Honor, we would agree that jurisdiction over custody has been conceded. It has been conceded twice. And that is not an appropriate question for
Right,
this.
but did your client forfeit the forfeiture or waive the waiver, as we used to say? Because he didn't make that argument, so he didn't have an opportunity to respond to it.
We would not concede that it's been waived, but to the extent that the court wishes to consider it, we think it's a very easy question determined under the UCCJEA, and it simply comes down to the home state of the child, which again, no one disputes is and has been the District of Columbia.
Isn't it a little bit more complicated than just ascertaining home state, right? And the court can't exercise jurisdiction if at any time at the start of the proceeding concerning the custody of the child has been commenced in a court of another state having jurisdiction substantially in conformity with this chapter, that's 16460206A. And so don't we have to figure out substantial conformity, except that nobody has argued that either?
We think that
I didn't see that the trial court addressed substantial conformity. I didn't see. It just has never been raised, but it would seem to be the proper analysis under the UCCJEA.
we think under the UCCJEA and in particular, section 164601, the clear application of the statute governs finding that DC has jurisdiction over custody, as it is the only state that the child has lived in for the last 5 years. And again, no one contests that DC is the home state and has been the home state of the child, and that at the time of the commencement of proceedings in Albania, Albania was not the home state of the child.
Another potentially complicating issue on the matter of jurisdiction over either, I guess, custody or support is your opponent's reliance on the concept of comity and suggestion that that's a consideration that ought to have led the courts of the District of Columbia to acquiesce in or defer to the determination of the Albanian High Court that it had jurisdiction over the matters of custody and support. What's your response to the comity piece of the dispute?
Comity is not relevant, but is essentially accounted for in the statute. Comity is accounted for in section 46352.04, which governs this exact circumstance of simultaneous support proceedings. And it unambiguously provides that a DC court may exercise jurisdiction over a support complaint filed second in time, so long as 3 criteria are met. And all 3 of those criteria were met here.
That's permissive, not mandatory. And so it doesn't clearly displace the idea that in determining whether to exercise the permissive authority conferred by the statute, the District of Columbia courts ought to take into account comity to some degree. So are you suggesting that you use the word relevant? Are you suggesting that the idea of comity is completely supplanted and irrelevant because of the provisions of the UCCJEA?
We think that it's accounted for in the statute and the 3-part criteria in which the court determines whether it. I agree that there's 2 questions. First is, does the court have jurisdiction? Can it exercise? Second is, should it? Is the DC court a more appropriate forum for exercising jurisdiction over this matter, which, to your question, could be perceived as a measure of comity. It's a judgment. And here, the court twice determined, in fact, 2 separate judges, first Judge Pittman and then second Judge Crane, 6 months apart, determined that DC was the more appropriate forum to issue a determination over child support. And in reaching that conclusion, it relied on several well-reasoned justifications, including one, the urgency. They found that it was in the best interest of the child to issue a timely resolution of this matters because the child had been without any support for years since the Mr. MATAJ's arrest in September 2020. The DC court further found that it was that the district itself had a strong interest in exercising its jurisdiction and resolving these proceedings because there was a concern that the child would become dependent on government benefits. And the district itself had an interest in ensuring the timely resolution of these matters to avoid that. Beyond that, the district court in DC pointed out that matters were significantly more further along in DC. At the time that Mr. MATAJ moved to dismiss, not 1, not 2, but 3 temporary custody orders and 1 temporary support order had been issued in DC. One of them he consented to, and another one he voluntarily negotiated with the aid of counsel. Beyond the negotiated agreement's reach, we had a trial set for a month's time, and the court had ordered and the parties had completed substantial financial discovery. So the evidence was here, the parties were ready to go here, and that weighed in favor of the DC court exercising its jurisdiction over the matter.
Can I ask you, just wrapping back to the abstract question of the relationship between the UCCJEA provisions and comity. I mean, I take an aspect of what I think your point is, which is that the analysis dictated by the UCCJEA touches on a lot of topics that might ordinarily be thought of as a more freewheeling comity consideration. So some of the ideas that are reflected in comity are already taken into account to a degree in the requirements of the UCC JEA. So I get that line of thinking, but just to make sure to fully understand your position, do you acknowledge that, notwithstanding that point, it's possible in certain circumstances that a judge might look and say, yes, the UCC JEA has been complied with, so I may exercise jurisdiction. And some of the factors that I've just considered are relevant to comity, but nonetheless, I still have to a degree, independent comity obligation, and a court might end up saying there are unusual circumstances here or usual circumstances, but outside what's contemplated by the UCC JEA that suggests that comity should persuade a court in the Superior Court or another court that's applying the UCC JEA to decline to exercise jurisdiction that it was authorized under the UCC JEA to exercise.
Yes, and I think that's what the word may does in the statute. It says the court may exercise jurisdiction if these three criteria are met, and it leaves up to the court that decision whether or not it should. And in determining whether or not it should, these principles of comity are considered. But I think what I heard my friend on the other side doing before was conflating principles of comity with principles of perhaps collateral estoppel or res judicata. And we would submit that those principles actually support that the DC court order should govern, as the DC court was the first court to issue an opinion on custody and child support. And with knowledge of that opinion, Mr. MATAJ voluntarily chose to continue pursuing proceedings in Albania, even though a binding and enforceable order in DC had already been issued. So to the extent he contends that he is subject to two court orders, that was of his doing.
Well, that's not properly before us right now, right? You agree with that? Talking about the court's discretion to exercise its jurisdiction over custody or support, I guess. It's just very unclear to me what the framework is for that exercise of discretion. The court, in its order dismissing the second motion to dismiss the November 2023 order, does go on to do this, yes, I think I should exercise discretion analysis. It cites no law. And so it's just not clear. And it certainly doesn't mention comity or however you pronounce it. And your brief doesn't cite comity or comity, even though that is an argument that Mr. MATAJ is making. And so I just feel a little bit at sea here. Like, what are we supposed to be looking at to figure out whether it is comity even an actual concern? I mean, the one Supreme Court case Mr. MATAJ cites talks about judgments. There's no judgment here at this juncture when the court is making a jurisdictional assessment about custody and support. Your brief just doesn't really meet Mr. MATAJ's argument such as it is. And so I'm left, and the trial court didn't really give us much of a framework for its analysis. So I'm left a little bit at a loss as to how we're supposed to determine whether this was an abuse of discretion or not. Certainly the court says things that sound reasonable. I just don't know what the framework is for us to assess the reasonableness of its decision.
I think the court provided ample justification for affirming its decision to exercise jurisdiction. As I mentioned, it at length spoke about the fact that proceedings were—
what's the framework that we should be looking to?
The statute itself, 46.352, while it
I think
says—
we're beyond the statute. Once the statute is satisfied, what's the framework that you think that we should be looking to assess the reasonableness of its determination that it should exercise discretion?
I think it was a factual determination, and that there is not per se a statute that sets out additional specific factors that the court shall consider in determining that question of whether it should exercise jurisdiction or not.
There may not be a statute, but there are clearly principles at play. And Mr. MATAJ has cited one principle that your brief doesn't address. So, or at least not squarely. I think I did a word search and I didn't find that word in there. So is that a proper principle that we should be thinking of?
I think that comity is, again, the applying those principles. is
What does comity mean to you? What would you tell us it is?
a judgment by the court in deciding whether or not it should exercise jurisdiction over matter. And in doing so, considers judicial efficiency, the interests of the district and the court in resolving the matters, the interests of the parties. And here the court did that. It said, the best interests of the child govern a timely resolution of these matters. And the matter has lingered in Albania for years, in part because Mr. MATAJ didn't serve Ms. MATAJ with his complaint for over a year. So it looked at the timing and said the district has an interest in a timely and efficient resolution of the child support determination. The child has a strong interest in the timely resolution of these issues. In terms of judicial efficiency, we have engaged in substantial financial discovery here. The parties have submitted years' worth of bank statements and W-2s and pay stubs. Evidence had been put into the record with respect to the child's care, his expenses, and other questions, other facts that go to making a determination. And the court, again, looking at principles of judicial efficiency and judicial economy, said, we are best positioned to move forward in resolving this. We have all the evidence here. He's agreed to multiple custody and support orders here, whereas in contrast, in Albania, none of that had occurred. No discovery had occurred. Really nothing beyond initial proceedings had occurred. Ms. MATAJ at this time was just allowing her lawyer to first begin appearing in Albania. So the court looked at these competing pace of the cases and decided that it was in both the child's best interest, the party's best interest, and the district's best interest to be the forum to resolve this dispute. And I see that your honor touched on this earlier, and it's to the extent that Mr. MATAJ asserts that the DC order is valid, but the Albanian decision should control. There is a separate procedure for seeking a determination of a controlling order under section 46-352.07. Mr. MATAJ has not initiated any such proceedings, but to the extent that the court liberally construes his pleadings as a pro se litigant, as Judge Easterly, I believe you touched on earlier, we would invite this court to reach a determination, if it was so inclined, as to which order controls. We believe it has all the information necessary to do so, again, as it's undisputed that DC is a home state of the child. And as I see my time is about to expire, I will conclude by noting that Mr. MATAJ has avoided his child support obligations for well over 4 years, and he continues to use the pendency of this appeal and this proceeding to continue avoiding those obligations. And so we ask that this court timely affirm the lower court's well-reasoned and thorough 87-page opinion on custody and child support. Thank you.
Thank you very much. Mr. MATAJ, we'll give you a couple of minutes that you can use to respond to the arguments that Ms. Jacobs made, if you wish.
Yes, so I'll try to wrap it up. The reason the DC moved faster, the DC courts moved faster, is precisely because we had simultaneous proceedings. The appellee has missed six court dates in Albania, prolonging that procedure. I did enter one temporary agreement. I did not waive comity or jurisdictional objections at any point. And I entered the temporary agreement precisely because the child needed support. And as far as sorry, I just made some notes here that I can't read. I apologize. But as far as the complaint in Albania, it is different than the United States. So this notion that I did not properly notify appellee is incorrect. In Albania, the court must inform the other party of proceedings. So in conclusion, I just want the court to really think about comedy, because if we decide to ignore the Albanian High Court ruling, we do invite other states to ignore US Supreme Court rulings in a reciprocal fashion. And I think that sets a dangerous precedent. Thank you for your time.
Thank you very much, Mr. MATAJ. And thank you for your briefing and argument on the other side. We will take this case under advisement. And whenever you wish, you can log off, Mr. MATAJ. Hopefully someone told you how to do that.
Okay, thank you so much.
Thank you.
Thank you.
The third case on this morning's calendar is numbers 23 CF 286 and 23 CF 287, Ronald Perry Burton versus United States.
Thank you, Your Honors, and may it please the court. Sean Bellinger on behalf of Mr. Burton. I'd like to reserve 3 minutes of my time for rebuttal. The 2016 case should be dismissed because the prosecution failed to bring Mr. Burton to trial within the 120-day deadline set forth in Article 4 of the IAD. This case is unusual because of the overlap between Article 3 and Article 4. The prosecution requested a writ for Mr. Burton before it received Mr. Burton's Article 3 request, and accordingly, this case is governed by Article 4, not Article 3. However, the prosecution never alerted the court to the IAD deadline, either during the initial proceedings or when the trial date was set. The first mention of the IAD was made by the defense during a June 2nd status conference, trial readiness hearing. Although this was 3 weeks before the 120-day deadline was set to expire, the prosecution still said nothing. It made no effort to advance the trial date. And in fact, the prosecution did not mention the IAD until it responded to Mr. Burton's motion to dismiss after the Article 4 deadline had expired. The failure to bring Mr. Burton to trial is entirely attributable to the prosecution, and the remedy is clear. The 2016 case must be dismissed.
Counsel, I'm sorry, when did your client move to dismiss on IAD grounds?
June 27th, 2017. Oh, excuse me. He moved to dismiss he noticed the IAD violation on the June 2nd hearing.
What
And
did he
then-
say at that hearing about IAD?
He stated there was a sidebar, and you can infer from the record there was some prodding by Mr. Burton. And he stated there had been a speedy trial violation under section 1322, 231322, and that the IAD had also been violated.
And was that accurate at the time it was said? Was it in fact, had the IAD been violated at the time of that hearing?
The IAD had not been violated at that time. The IAD under Article 4 would have been violated on June 20th.
Right, so the oral objection, it taken literally, was not, it was premature, I guess. It was, so there was no violation. The assertion was there's a violation, answer no violation. And then the trial court said, I need to have a written motion. Is that right?
That's correct.
And that then the written motion is filed June 27th, which is after the 120-day deadline, if that's the applicable deadline.
Correct. And
Part of your comment goes to the issue of forfeiture, whether this issue was adequately preserved in the trial court. And it's a line of thinking that was suggested by what you said today and in your brief, that the obligation to secure compliance is solely the prosecution's, and what you seem to be relying on that idea for is therefore there is no obligation to raise the issue at any point in the trial court. Is that your position, so that if there, was someone, a detainer is lodged and somebody is brought in, and leave aside under which article or both, and then the deadline's run and there's just complete silence about the IAD until, let's say, day 200, when whichever deadline it would be would have run. And you would say, that's fine. There's no obligation to raise it. The duty is entirely with the prosecution, and it can be raised after, at a time when the only remedy is dismissal. Am I right in inferring that's the line of reasoning?
Well, under Hill, that case is about sandbagging. So here, Mr. Burton did raise an IAD issue. And under Hagler,
Right,
under
but,
this.
my question is less about this case and more about what your position is. And so in the case that I was postulating, is your answer not necessarily preserved? Might depend on more, or is your answer yes, that's always preserved? There's never an obligation in the trial court to timely raise before a deadline has run the IAD? I'm just trying to figure out what your position is about the framework you're asking us to impose on the question of issue preservation.
Understood, Your Honor. So if Hill is about sandbagging, and that is if they agree to a date that's after the IAD deadline, then they can't stay silent. I think that under this court's cases, if there's no trial date set beyond the deadline and it's just, there's no hearings, the defendant could stay silent. And if at the first hearing, is beyond the 120-day deadline, I think there would be no waiver in that.
Or I mean, I think in one of your briefs, you said a recent Maryland case that seems to draw a distinction between affirmatively, like, requesting or expressly acquiescing in a trial date outside the applicable deadlines and just being silent when one is set. Would you advocate also that approach? So in other words, if, let's say, someone is brought in under the IAD and a trial date, there's a hearing at which people are setting a trial date, and the trial judge proposes a date and asks for objections, and there's no objection from the defense, and that date is outside the applicable deadline. Would you think that issue has adequately been preserved because the only way you forfeit it is by expressly acquiescing in a trial date outside the applicable deadline?
No, Your Honor, I think Hill, dispels with that distinction and really drills back into sandbagging. And that is sort of a fact-intensive inquiry. And
So the issue here, in your view, is should it be viewed as sandbagging to orally make an incorrect statement that the IAD has already been violated, and then to wait until after the IAD deadline that the defendant thinks is applicable to comply with the judge's directive to file a written motion? Is it so that's the question you think is we should look at those events and decide whether we view that as sandbagging or not? That's
correct, Your Honor. And I'll say why it's not sandbagging in this case. And that's because from the defense's perspective, Mr. Burton submitted an Article 3 request, and he's written to DC thereafter. There's a complicating factor here, and that is that the prosecutor, on her own volition, issued an independent Article 4 writ, requested an Article 4 writ prior to receiving Mr. Burton's.
I don't understand. I'm sorry. This doesn't seem to be about the 120 days versus the 180 days. I thought that your June 27th motion was saying that the 120-day deadline had expired. And so the question then, if I understand what you're saying correctly, is we have to figure out whether the failure to file that motion until 25 days after an IAD issue was orally raised before the trial court was sandbagging, right?
Yes, Your Honor.
And I mean, why wouldn't it seems that the facts are not terribly favorable to you if the IAD issue was raised at the June 2nd hearing. albeit with some confusion about the timing and some argument that the IED deadline had already expired. And then the court says, give me a written motion. And one would think one would want to file that motion immediately. And yet 25 days go by, which spans the time when the IAD deadline actually expires. And then the motion is filed. That doesn't seem like a great fact pattern for you.
The reason that Mr. Burton raised the issue on June 2nd and then filed the motion on June 27th, written motion on June 27th, was because he thinks it's an Article 3 case at that time.
He
And-
thought it was an Article 3 issue in the June 27th motion, right?
He thought it was Article 4, the 120-day. Article 3 is the 180-day deadline, and Article 4 is the 120-day.
I'm sorry. Okay, so
And-
you're saying he thought the deadline was longer when he incorrectly said the deadline had already expired on June 2nd, and he thought it was shorter when he said that the deadline had expired on June 27th.
Your Honor, I think you can infer that from the record, and I think that that complicating factor.
Well, he's clearly talking about the 120-day deadline on the 27th.
Clear,
That's-
yes,
that's
you're right.
in pleading, but the.
Right.
And how can we infer what he was thinking in the oral? I mean, inferentially, I agree. It seems like he was prompting his lawyer to raise the IAD. That seems to be the context of it. But how can we infer what his thinking was about whether he thought Article 3 or Article 4 applied? I mean, I just don't see much of a basis. It seems as though, understandably, if he's not a lawyer, it's a complicated set of provisions, so he may not have understood how it was operating. But beyond that, I'd have a hard time creating some inference, nor would I wouldn't necessarily want to hear representations outside the record about what in fact the defendant was thinking. But if we're just inferring from what happened on the 2nd, certainly the difference between Article 3 and Article 4 doesn't leap to mind as an inference. It's a possibility, although it's an odd possibility, because as Judge Easterly's question suggested, if he was thinking that Article 3 applied and the 180-day deadline applied, then it's even less understandable why he thought it had already run.
Understood, Your Honor. So the drafters of the IAD placed the burden on the prosecutor to really inform the court of the IAD deadlines. And this case is a perfect example that because of the informational disparity between the prosecutor and the defendant, so the defendant is in prison, gets a detainer, makes an Article 3 request that says he's going to be tried within 180 days of the receipt of that request. He doesn't know that the prosecutor, on her own volition, files a request for writ before that under Morrow, initiating the proceedings. And
How does he not? You're saying he doesn't know that as of June 2nd, the June 2nd hearing, he doesn't know that?
he doesn't know it until his defense attorney digs up the postmarks on the the Article 3 request that show that
Are you saying that, I mean, you say digs up, but would I would have assumed, though, maybe the record doesn't shed any light on this, that a prisoner who is subject to what Morrow says is a request for temporary custody in the form of a writ of habeas corpus ad prosequendum, if that's the right way to pronounce it. I assume that's served on the defendant, but your point is you can't tell the exact sequencing of things until you go back and try to find out exactly when your client's request was in various mail rooms and received at the U.S. Attorney's Office. That's what you think isn't immediately accessible to the defense and required further investigation.
exactly, Your Honor, and it is immediately accessible to the prosecutor.
And can I ask you, so this gets to the merit, less to forfeiture and more to the merits of which of the deadlines applies. But I know it's critical to your argument, if I understand it, that it seems to be the chronology that you've provided seems to indicate that the prosecution had independently decided to seek a remedy under Article 4. Then it wasn't prompted by a prior request known to the prosecution of a request under Article 3. That's you provide information that seems to support that, and and you also take it as undisputed from the United States because you made that argument in your opening brief and they didn't contest it factually. So you think we should take that as a given, which is the decision here of the United States to seek a remedy under Article 4 to bring your client in was independent of the decision of your client to invoke Article 3. Is that, so far you're with me?
That's correct. And the government's brief says, I think it's quote, apparently they did this on their own volition. So I think it's close to, it's a concession.
Right. I'm just curious exactly where you draw the line. So, and how this would proceed. Imagine that the timing were not apparent. So that, I mean, imagine that your client's request had been received by the U.S. Attorney's Office on day X, and the writ was on day X plus 2. And so you can tell the sequence of events, but you can't draw an inference necessarily about whether one was caused by the other or independent by the other. Is that then, you think, the answer to which deadline applies turns on kind of discovery and maybe testimony about the subjective reasoning of the person in the U.S. Attorney's Office who filed the request for temporary custody? So it would depend on, it was there, it was available, but who knows, was it, what caused what would be a question of fact sometimes rather than chronology, as it seems to be conceded here. But is that right? Your view would be where the chronology isn't make it obvious, that might be a matter for discovery and testimony and hearing about what the subjective purpose was, whether it was an Article 3 response by the prosecution or whether it was a independent, would have done it anyway for our own reasons, we were proceeding under Article 4. Is that how your test would work?
Your Honor, I don't think you would need to get into the subjective reasons. I think it would be, I think the sequencing here makes things clear.
Right, but I'm asking,
understood.
Sequencing doesn't, what rule are you asking us to adopt? Would you say, as a matter of law, if the sequence of events is request by the prisoner under Article 3, receipt of that request by the prosecuting entity, then thereafter a petition for writ of habeas corpus ad prosequendum, you would say 180 days applies, or does it depend on exactly what the connection was between those events, even if their chronology is that?
So I think Morrow somewhat answers this questions as far as what the deadline is done by what is actually effectuating that. And I understand.
Well, for sure,
right.
Morrow tells you that the petition for a writ of habeas corpus ad prosequendum after a detainer is going to be treated as a request for temporary custody under the ID, for sure. And so maybe to simplify the hypothetical, imagine what is sent from the prosecuting entity after receipt of, though who knows what, thinking about receipt of the Article 3 request from the prisoner, if what is sent is a request for temporary custody under the IAD. Let's assume that's what's sent. So you can avoid that complication. Is your view that you need to inquire about, it's not just the factual, it's not just the chronology of it, it's the causal connection among these events that also is critical. That's what I'm asking, I guess.
I think Morrow says that the causation is important. I don't think that needs to be an extensive inquiry, and especially not here. Morrow holds that whatever initiates the disposition of charges controls the article. I want to add that there's no support in the statute for applying the later of two deadlines if it's even close. because the statute holds that the purpose of the ID is to dispose of the charges in the detainer as expeditiously as possible. It would be sort of contrary to that conclusion to pick the later date, which,
But I mean, it
But
can't
that-
really be the purpose to make it as expeditiously as possible. Then they wouldn't have 180 days or 120 days. It would be do it as expeditiously as possible. So it's intended to create a reasonable and orderly system that makes, doesn't result in undue delay and is done as timely as is consistent with doing it in an orderly way. So it seems like a bit beyond what the statute is intended to say that trial pursuant to the IAD always has to be as expeditious as possible.
so it's supposed to be liberally construed in favor of the prisoner. If there's a close call,
Can you ask, so I know there's a dissenting opinion that is cited in your briefs that says that. What is more typically said is it needs to be interpreted liberally in light of its purposes, which is somewhat more opaque. But do you think we have authority or there's controlling authority from this court or the Supreme Court that suggests that it needs to be interpreted liberally in favor of the prisoner rather than this more general language about liberally in service of its purposes?
I think there's statutory clues that the language of the statute shows this is done for primarily for the prisoner to avoid the abuses of the previous system.
And my question is not nearly as sophisticated as Judge McLeese's. What language of the statute do you want us to be looking at? Right, we're looking at Article 3. Just point me to where we're talking about 120 days and 180 days. Right, we're looking at 3A, is that right? Talks about 180 days after he
Yeah.
shall have caused to
Yes.
be delivered to the prosecuting officer,
And if you,
right?
yes,
And
you're
then-
right.
And then we're looking at Article 4,
C, I believe. And if
which
you,
is trial shall be commenced within 120 days after the arrival of the prisoner in the receiving state.
correct, Your Honor. And so
Okay.
there's two different triggering events. They both, the statute, to the extent that the requirements in Article 4 are met, to therefore waive them because in Article 3 is inconsistent. You'd be reading Article 4 out of the statute if,
Well, but I take your point to a degree, but it seems like it might prove too much. If, and maybe that would at bottom be an argument that Felix was incorrectly decided, but if I take you to have acknowledged that if the sequence of events is prisoner files a request under Article 3, after there's a detainer, prisoner files a request under Article 3, and then in response, as an effort to achieve what the prisoner
Right.
has requested,
right,
the prosecution files a request for temporary custody or a petition for writ of habeas corpus ad prosecundum, which Morrow says is equivalent under the IAD for request for temporary custody. When those things all happen, 180 days apply.
that's correct, Your Honor.
Doesn't
We're
that
not-
read, that reads the language of 4C out, because 4C says, in a proceeding made possible by this article, trial should be commenced within 120 days of the arrival of the prisoner. So, Felix itself and what you're conceding seems to, at the most basic, basic's not the right word, but in the broadest way in which you're pitching your argument, it seems to be inconsistent with what we held in Felix and inconsistent with what you're conceding.
Not with it. Our case is distinguishable from Felix.
Fully understand that
Right.
argument. My only point is if
Right.
your argument is you just have to look at C in isolation and you have to say if its predicates are met, there has to be a 120-day deadline. That's all you need to know. That is inconsistent with Felix because those requirements were met in Felix and we said no, 180 days apply. I know in circumstances that you view as distinguishable, but my only point is the argument that all you need to know is C and anytime it is triggered, 120 days apply. That seems inconsistent with Felix. And what Felix seems to say instead is when both things are triggered, you need to figure out, you need to figure out which one governs. And Felix said in language that is, in its breadth is not helpful to you, said, really doesn't matter the mechanism. It's, if the prisoner makes a request under Article 3, it's 180 days. Now, I know your argument is that's in its context, but
Right, correct.
I think it's just hard to think that our approach really could be look at C and for C in isolation, and if its requirements are met, the answer is 120, because Felix is inconsistent with that. Do you agree with that?
I agree that Felix would be inconsistent with that.
So we have to do something to accommodate situations where both seem to have been triggered and they're different calendar lengths, and they're also different triggering mechanisms. And courts around the country, I mean, this is intended to create uniformity, but courts around the country have, I don't know, 4 or 5 different options that they've picked. So there are lots of different, because the statute doesn't really give you good guidance about what to do when both are triggered. So courts are kind of groping to figure out, well, what do we do? And we said what we said in Felix. Other courts have said other things. I think, some courts say if both are triggered, then comply with both. And as an original matter, I can see the logic of that. That seems more, in some ways more textual.
Exactly.
So I can see that line of thought for sure, but that's not available to us. I mean,
Right.
Felix said otherwise.
Right.
So then the
Right.
question is how to understand Felix. And would you agree that Felix has in its language, it has language that by its terms would tell us that we should apply 180 days here, unless we say, well, you've got to understand that language in its context and don't read it as broadly as it's written. Do you agree with that? That there's language in Felix that in isolation would foreclose relief to your client?
I don't agree with the latter point. Felix it distinguishes Morrow because in Felix, the government sought the writ after the defendant. And that was an important point for Felix. And it was done for the sole purpose of facilitating the defendant's Article 3 writ. And I think that was a crucial to the holding to distinguish Morrow. So the court in Felix does acknowledge when Article 4 is triggered. It doesn't disagree with Morrow's point about when Article 4 initiates the disposition of proceedings, that the 120-day applies. I do think
the language in Felix, one of the sentences, there are others, but the one example, which is the paragraph right before part 4 of the opinion, where we're summing up what we're doing, and we say, accordingly, we hold that the 180-day limitation applies whenever the prisoner initiates the request for final disposition of charges, irrespective of the means by which custody of the prisoner is obtained. That language seems to be dispositive unless we say, well, yes, that's broad language, but we have to understand it in light of the circumstances of Felix. But do you think that if you take that sentence, you think if we apply that rule of law as it is written, do you think your client can prevail?
Yes, Your Honor.
And so how would we conclude that? So we've now held 180-day limit applies whenever the prisoner initiates the request for a final disposition of charges. Do you think that happened here? Prisoner initiated a request for a final disposition of charges.
The prisoner the prisoner made a request, but it didn't initiate the disposition of charges because the Article 4 request initiated the disposition of charges because it's first
the
in
wording
time.
is initiates the request for a final disposition of charges. You don't think your client initiated a request for final disposition of charges?
No, he initiated a request for a final disposition of
He
charges.
did that. And then it says the 180-day limitation applies whenever that happens. And not only did we say that, but then we said irrespective of the means by which custody of the prisoner obtained, which is, off onto writs of habeas corpus ad prosecundum or other requests for temporary custody. So I don't mean to foreclose your further response, but I'm having trouble seeing how if we apply that language, your client can win. I thought your argument had to be there's broad language in Felix, but you have to understand it in the context. And that was a context where the prosecutor's effort to bring the prisoner in was chronologically, it was undisputed that it was in order to respond to the prisoner's request. And you think it's limited to that. And if instead the prosecution is off on its own independent plan to bring the person in under Article 4, then Article 4's deadline can apply.
Right. So our argument is the reading of Felix in its context supports our position. But even that phrase, when they're referring to the transfer of custody, I really think they're referring to the fact that the writ in that case was not the initiator of the disposition of charges. It was used to merely transfer custody. And I think that's why they stated that the way they did there. I didn't read it as essentially disagreeing with binding authority in Mora, which would have been whenever Article 4 and whenever a writ initiates the disposition of charges, in fact, initiates the disposition of charges, Article 4 applies. So I didn't read Felix as.
Why would that be inconsistent with Morrow? If, let's say that it literally, one were thinking of Felix in isolation as a rule that said, if a detainer is filed and a prisoner initiates a request for final disposition of charges within the meaning of Article 3A, now we know 180-day calendar applies. How would that be inconsistent?
Well, in Morrow, they stated when the prosecutor files the writ first, and it in fact initiates proceedings. So then
the premise of this sentence was that the prisoner has initiated it. So why would attaching a consequence to prisoner initiated cases be inconsistent with Morrow's holding about government initiated cases? I'm not quite sure I see the conflict.
I think under Morrow, if the prisoner filed their Article 3 request after the writ, I think Morrow holds that whatever initiates
right,
that.
and that I agree with that, but the sentence in Felix is this seemingly sweeping language considered in isolation is triggered when the prisoner initiates the request. So nothing in Felix could be inconsistent with Morrow's view about what happens when instead the request is initiated by the prosecution, including by filing a detainer and then filing a petition for a writ. So I'm not quite sure.
Understood, Your Honor. I was focusing more on the earlier. I was confused. I guess the earlier you were stating about they filed a notice to initiate the disposition of charges or request for disposition.
The wording in Felix is initiates the request for a final disposition.
Okay, there's nothing inconsistent with, apologies, Your Honor. So I see I'm over time. If I could just briefly touch on the other crimes issue.
Please.
Okay. So the prosecution twice was unable to convict Mr. Burton based on evidence relating to the SN case itself. So at the third trial, they pull out all the stops and they introduce two other offenses. And at the third trial, more time and more witnesses were spent towards the other offenses than they were related to the SN case itself. There was 20 of 38 government witnesses were related to other crimes other than the charged crime. So starting with the ZN evidence, we're arguing that was irrelevant because it was the government was stopped as a matter of law from arguing the way Mr. Burton entered into SN's home was irrelevant as a matter of law based on the burglary acquittal.
Could I ask you that, was there, your sentence there combined a number of thoughts, but focusing on the word estoppel, which I don't remember seeing in the brief. Is your argument that the ZN evidence should have been excluded because it was inconsistent with the prosecutorial theories at the first two trials? There is a fleeting reference to that idea in your brief, although the word estop is, I don't recall used, but is that what you're referring to?
It's inconsistent with the prosecutorial theory. It's inconsistent with the facts, and it's inconsistent with the burglary acquittal, which between the first and the second trial, there was a discussion but, with the court about the effects of the burglary acquittal. And during that discussion, the prosecution admits that they can't argue that Mr. Burton tried to enter SN's home for the purpose of committing a crime.
Can I ask you about either your inconsistent theory argument or your double jeopardy estoppel arising from the acquittal of burglary in one of the first two, maybe it was the first of the two
The first, yes.
trials? Were those raised in the trial court as grounds for exclusion of the ZN testimony?
So when,
In the third, in connection with the third trial?
yes, Your Honor. So we're not arguing the double jeopardy estoppel. We're just stating that the government admitted that it wouldn't be able to use that evidence, the government admitted that the way that it could argue Mr. Burton entered the home was irrelevant.
However, you're characterizing this argument, was it raised in the trial court
yeah.
as a grounds for exclusion?
Yes, Your Honor.
And is that point, I mean, there are a set of points in here, but the idea that the burglary acquittal was an obstacle. I remember somewhat passing reference to that in your brief, but is that an argument that you believe you presented to us for decision? So is it an objection in the trial court, and you think you presented it to us?
So let me be clear about the objection to the ZN evidence. The defense argued in opposition that the doors weren't, that the prosecution has never established that the way Mr. Burton supposedly entered into SN's home was relevant. So in the estoppel discussion was in between the first and second case, and that was the parties got at a hearing. The parties discussed about how they could try the case again with the state of the evidence as it was and with the acquittal, and the government admitted at that point that she couldn't argue that Mr. Burton entered into the home to commit a crime. So we don't present a classic estoppel argument, and we're only presenting that argument to the extent to show that it didn't meet the Drew factors because it was not relevant. It was no longer relevant.
Well, I mean, leave aside the double jeopardy, possible estoppel from acquittal, or some other form of estoppel from statements that were made in connection in between trial one and trial two, or the due process theory of possible shifting of government, prosecution theories. So those are all thoughts that are floating around. I'm unsure how clearly they were presented in the trial court, how clearly they're briefed here, but leaving those obstacles aside for a minute, and just as a matter of original relevance, is kind of, relevance on a clean slate. Are you disputing that in the third trial, imagine the third trial had been the first trial, so there weren't any obstacles relating to the topics you've been flagging, do you think that the ZN evidence would be irrelevant?
I do, and the government admits that much in their closing. After the ZN evidence is admitted in their closing, the government states it doesn't matter whether or not the doors were locked.
Admission of irrelevance. I thought the line of thinking was, to the extent the defense is consent, and an aspect of the defense is, if it weren't consent, you'd expect signs of forced entry. There are two possible, this is all a big paraphrase, but just in terms of conceptually what I thought the line of thinking was there are two possible explanations for that. One is that the complaining witness may not have, the first door, I think it was acknowledged, probably didn't lock. And the other two, the complaining witness may not have may not have locked, though that was her normal practice. possibility number one. Possibility number two is that your client was able to get through those locks, even though they were locked, without leaving signs of forced entry. And then the prosecutor says in closing something like, doesn't matter which of those two possibilities is right. It's just that because they are both there, you shouldn't have a reasonable doubt arising from the lack of forced entry. Why isn't that a relevant line of thinking? And why is the idea of saying it doesn't matter which of those two is right? It doesn't seem to me a concession that being able to show that there are at least two possibilities is irrelevant.
Your Honor, I don't think they state that in their closing, that it doesn't matter whether those two possibilities are right. They state it doesn't matter how he entered into her home, and therefore the government never disputed.
Well, they do think it would matter if she let him in, as was the defense theory, right? It's not that it wouldn't matter at all.
So the defense theory is that he was let in. The government's theory is it doesn't matter. That's not genuine. That's not a genuinely
Well, you gotta
disputed
be clear
issue.
about what you mean by it there.
Excuse
And that's
me?
what Judge Beckl's question is directed roughly at. What do you mean by it there? It would matter if the way he got in was that she let him in as part of an agreement to have consensual sex. So how she got in did matter to that degree. But whether he got in, as long as it wasn't with her consent, which really nobody was suggesting there was, maybe that scenario was floated. I don't know. I haven't fully read all the transcripts, some of which we just got made available to us. But I think the defense was suggesting it did matter that there was no sign of forced entry because it suggested consent. And the government was arguing it doesn't necessarily show lack of consent. There are at least two explanations. One of them is she forgot. The other is he's apparently good at getting through, or has the ability to get through locked doors without signs of forced entry. That all seems like perfectly normal, relevant argument to me.
Yeah, I don't think that the prosecution presented that in what you're saying in the terms of it, there's two possibilities. I think it was more to the effect of it doesn't matter. And if you relate that back to the discussion between the first and second trial, the prosecutor at that conference, when they're talking about the effect of the acquittal, states that she needs to prove that the intent to commit the offense manifested after he got into the home. So from the government's position, their entire case starts after he gets into the home. They don't dispute that however he got into the home is relevant, because their entire case has to hinge on what happened after he got into the house. And so under Drew, it's not a genuinely materially disputed fact that they could enter other highly prejudicial other crimes evidence, 8 additional witnesses. And just to touch briefly on the AW evidence as well, we're arguing that was not narrowly tailored. There was 12 additional witnesses. There was evidence introduced about her phone being stolen that has nothing to do with overcoming consent, the purpose for why it was admitted. There was nothing, it discussed AW's emotional injuries. Again, that has nothing to do with overcoming consent, and it's not very tailored, and it's highly prejudicial. If there's no further questions on other crimes, I could just very quickly on the 2019 case.
Okay.
So the first as we laid out in our brief, Mr. Burton was deprived of his speedy trial rights under 2019 case as well, because he should have been returned and he wasn't. And therefore, when he came back, he would have had the benefit of the IAD speedy trial right, which he didn't, because he wasn't returned in the 2016 case as he should have been. And the second issue is the merger issue. lesser included offenses should merge with the completed sexual abuse because they all arose from the same continuous struggle. And there was no fork in the road. There was no distinctive separate decision by the assailant and in those events. So nothing further. I'll just reserve the remaining of my time for rebuttal.
Okay, you have no time remaining, but we'll give you a few
Okay.
minutes on rebuttal. Thank you. Hear from Mr. Goodhand.
May it please the court, David Goodham for the United States. I'd like to take the issues in order if I could, starting with the issue of the defendant's waiver of the 120-day clock. A lot of suggestion that this was the United States' responsibility, that we had a duty to inform the trial court and the defendant of his rights under the IAD. I would just direct the court's attention to the Hill decision, which I think is pretty clear on where the sort of onus lies. And in particular, I would direct the court to page 664. Hill says, absent a demonstration of ineffectiveness, counsel's word on such matters is the last. And so such matters being issues of the conduct of trial, including calendaring. So what we have here is at the March 30th, 2017 hearing, trial counsel, defense counsel wanders into court and says, I'm invoking the 100-day clock of 1322, affirmatively asked for a July 5th trial date. So there's no question I would suggest about whether or not this was sort of just silence agreement that was acquiescence. Then we have a couple subsequent hearings thereafter. We have an April IPA hearing, then we have the June 2nd hearing, then we have a June 14th hearing. All of these are occasions where I would suggest defense counsel could have raised the IAD and the 120-day clock, but there was no mention of the IAD by counsel. I recognize that we've discussed the June 2nd hearing in some detail and whether or not the defendant sort of through counsel notation that the IAD had already been violated somehow constituted, I would suggest, a withdrawal of the waiver from March 30th. I just don't think that's possible for a couple of reasons. One, again, we circle back around to Hill, which is unless you demonstrate ineffectiveness, counsel's word is the last. Well, even at the June 2nd hearing, after the defendant sort of acting pro se, if you will, invoked the ID and said it had already been violated, even after that on page 25, I believe it is, his defense counsel doubles down on the July 5th date. So counsel, whose word is last on issues of scheduling, returned to the July 5th date, number one. Number two, of course, this court's case law is pretty clear on the notion that a defendant can't both represent himself and have counsel. It's either one or the other unless you have express approval from the trial court, and I don't think we have that here. So what we have, I would suggest, is sort of the classic scenario under Hill, which is a defendant counsel who chose a clock, didn't raise the issue of the IAD 120 days. And then after that clock had expired, we then get a clear motion referencing the 120 days. And I would suggest this sort of falls within the four corners of Hill. And I would also suggest that when you look at the events unfolding after that June 27th hearing and motion, June 27th motion, June 30th hearing, it was almost like a 5-car pileup. Motion was filed, the United States responds quickly, this hearing scheduled 3 days later. Very complicated issues are hashed out. Does the 120-day clock apply because service was perfected on December 5th, or does a 180-day clock, 120-day clock apply because he was brought into the jurisdiction in January? And, the court is wrestling with these issues. These are difficult issues, applying, a good faith, reasonable approach to this, and ultimately concludes, number one, that the 180-day clock applies, and sets the case for July 20th. Even then, when the parties show up on July 13th, again, the court is very assiduous. At this point, it's shifted to Judge Leibowitz. The court is very careful and assiduous. At that point, this is just a pretrial hearing. It's not the July 20th trial date. Judge Leibowitz looks at defense counsel and says, when do you think the 180 days expires? And defense counsel says, tomorrow, Your Honor. And because defense counsel disagreed with the notion that a good cause continuance had been appropriate. And Judge Leibowitz says, okay, let's impanel a jury. And they do on July 13th, which was a full week ahead of what everybody else until then was assuming was the appropriate date. So again, my only point here is this is why I think Hill came down. This is why Hill is comfortable with the notion that, yes, of course, we want to liberally construe the ID with the idea that we will, further its provisions, but we can't construe the ID to stand for the proposition that you can sit on your rights up until and past the expiration point and then say, you know what, I should have gotten 120 days. If I could just briefly, I recognize Felix, there is some tension in Felix. I read Felix to stand for the proposition that because these issues are so complex and there are many tests out there, I read Felix to stand for the proposition that let's endorse some clarity here. And so I think when you read the holding of Felix and the language of Felix, you get to the point where Felix says, at least when we have perfected service by the defendant, that is his request has arrived at both the U.S. Attorney's Office and the court, and we have him initiating these rights at his facility. When we have those two things in conjunction, at least at a minimum, when you have that, then we don't care about what prompted the writ of habeas corpus coming out of the U.S. Attorney's Office. And so I think Felix is looking for clarity. I think Felix applies clarity, and I think Felix is a good rule.
So do you think that is it your position that this has been forfeited and we don't need to grapple with?
Which is why I started with waiver. I mean, these are very complicated issues. And I think
just to clear the record, Judge Leibowitz never dealt with a waiver issue, right?
No.
Okay.
We raised that in our pleadings as an alternative ground for ensuring that the 120-day clock was not an impediment. Instead, Judge Lopez, it was actually who made the ruling on the ID, said, I agree with the government. He's only triggered the 180-day clock. He also made some findings about a good cause continuance, but he never addressed the waiver issue. But we did raise that in our pleadings and indeed argued it at the hearing, and defense counsel responded. But yes, you don't need to go down the Felix road. You don't need to address the complexities of these issues. You do not need to answer that question here because of the clarity, I would suggest, of the Hill decision and its ramifications for the defendant in this case. Briefly, there was an issue raised with respect to collateral estoppel and, whether or not that was properly raised and whether or not, for example, it had any impact on the judge's other crimes ruling. I would direct the court to page 25 of the January 31st, 2020 hearing. It is true, collateral estoppel comes up then, but it comes up in the context of AW. The other complainant, because they were discussing the issue of the cell phone and whether or not the cell phone evidence could come in. And defense counsel was pushing back on the notion that a stolen phone could be referenced as other crimes evidence in the SN trial. And so at that point, defense counsel, again, on page 25, talks about the acquittal, the phone of SN, and the assistant United States attorney says, well, okay, yes, that's true, he was acquitted. That means we can't argue that he had intent when he crossed the threshold, but we can certainly talk about things he did and intent that was formed after he crossed the threshold. and most critically, after he breached the locks via his skills. Unless the court has any other questions,
Sorry, just to clarify, I thought opposing counsel said something that there was discussion of the burglary, but I mean, it's only in this context. You're saying.
That's my understanding. And the other place where it might have come up would have been the defendant's opposition to our 403, other crimes motion, and that's at R1 172. And I didn't see anything there relating to collateral estoppel. Unless the court has any other questions, we would ask that you affirm the judgment conclusion below. Thank you.
Mr. Bellinger, give you 3 minutes.
Thank you, Your Honor. So quickly, the point about Hill and waiver. We went back and we read the briefs in Hill, and the petitioner's brief in Hill is particularly helpful here. Hill was an Article 3 case. The petitioner's brief notes that when he signs the Article 3 brief request, it tells him he's going to be there. He's going to be tried within 180 days. And so Hill was fully on notice of that deadline. And he remained silent, didn't say anything until after that deadline passed, even though a trial date was set past that deadline. This is different here because of the complicating factor of the overlapping requests. And Mr. Burton was not in any position to, the prosecutor knew from the outset about the issue with the overlapping writs, and she didn't state anything. She didn't move to advance the trial. She didn't note the trial to the trial court that the date was outside that deadline.
Just to be clear, when you say the prosecutor knew, I assume what you mean is that she was chargeable with knowledge in the sense that the information was available to the U.S. Attorney's Office of which she was a part, or do you mean that it was clear she subjectively had gone back and looked at the postmarks and it had worked out the chronology that was later developed?
No, Your Honor, it's chargeable. She knew or should have known the order of the writs, and the ID envisions that the prosecutor will have an informational disparity. They're in charge of the procedural aspects, and therefore it's their burden to bring the defendant to court within those dates. And the drafters of the ID took it very seriously that these dates were met, and they said if you don't meet these dates, then the case will be dismissed. The other thing is Mr. Burton did raise the ID issue at the June 2nd hearing. Regardless of under Hagler, that's all he needed to do. But again, the prosecutor didn't say anything at that point either. She didn't clarify, oh, there's actually this issue with overlapping writs and maybe we need to expedite the briefing on that. She stayed silent. She didn't say anything until responding to the motion to dismiss after the deadline was expired. And then quickly about the other crimes issue, the estoppel point, the hearing I was referring to is discussing estoppel generally throughout and the effects of that acquittal. Again, we're not arguing like a true straight estoppel argument with a double jeopardy in facts estopped, but we are noting that the same prosecutor who tried the case all 3 times stated that the way that Mr. Byrne entered into SN's home was irrelevant to their case, and they would have to, because of the acquittal, argue that the entirety of the sexual abuse offense would need to be proven after entry into the home.
Your opponent suggested that it was the acknowledgement was not, or either wasn't exactly that, or at least there was an ambiguity in how you just stated it. Is it entered onto the property, entered inside the house, entered inside the lock? So your opponent used some word like the threshold, but not necessarily the locks. And so do you understand what distinction he's trying to draw, or are all the locks external to the point at which you could have been guilty of committing a burglary?
So the record is not clear on that point. It is a general allusion to it, but again, it's the same prosecutor. The state of the facts were the way they entered into, Mr. Burton entered the home didn't matter. And the only time she expressly states that the prosecutor expressly states that SN's locks, the doors were locked, is in the motion to admit the other crimes evidence. That's the only time. And the first two trials, it doesn't matter. And then at closing, it doesn't matter.
Can I just clarify one thing too? You were referring to a hearing at which there was discussion of estoppel. Is that the same hearing that your opponent just mentioned, the January 31st, 2020 hearing? So we're talking about the same hearing and it's just a question of what happened there, or are you referring to a hearing that's separate from the one that was just referred to by your opponent?
I believe we're talking about the same hearing, and it's mentioned in our reply brief. I don't have the site on me right now, but I believe we're talking about the same hearing. And if there's nothing further, Your Honors, we ask that you reverse Mr. Burton's 2016 and 2019 convictions. Thank you.
Thank you very much. Thanks for your,
We'll provide the site to the record for that transcript that we were talking about.
if we can, is that okay? Okay, thank you. Thanks for your arguments today and for your briefing, and the case will be submitted.
All right.